autismsociety.org. Now, for those of you who do have questions, it's pretty simple. If you look in the control panel, which is probably on the right of your screen, you will see a bar that says questions, and you can just type a question in there, and then Feda and I can monitor those questions and then pitch them to Mark at the end. If necessary, we might pitch him some questions along the way as well. All of you guys are on mute, so don't worry if you're making noise. And actually, Feda and I will go on mute in a second as well, so we can give Mark the stage. What else do we have to say? Except we're really happy to have Mark here. Mark is an attorney at Gilfix in LaPole. It was a firm founded by his parents, really. And they have had a specialty practice in special needs planning for a long time. And we are just going to dive right into this. Mark, I'm going to hand it over to you. And thank you so much for being with us today.
Well, thank you so much, Jill, and to the Autism Society of the San Francisco Bay Area for giving me the opportunity to reach out to this community, because I think there's a lot of fear and uncertainty when we get into some of these legal and financial issues. So it's a privilege to get to speak about this. It's something that I'm passionate about, and as you mentioned, it's kind of a family legacy for me. So I'm hoping that everyone can see the slides that I'm sharing. So I'm just going to jump right in with a line that we hear all the time when it comes to special needs planning and what parents are thinking when they get to the subject. I'm afraid to die. We hear this or a version of this all the time. And it's not a fear about our own mortality, although I think as humans we all have that. This is really about who is going to be there in the future to take care of our son or our daughter on the autism spectrum or with any issue. Who's going to be there to fill our role as parents or even as grandparents? That's what this talk is really about, filling that role in a multi-generational way and hopefully putting some of your fears to rest and letting you know about the legal and financial resources that are out there and the steps that you can take to ensure a vibrant future. These are some of the questions we hear all the time, by the way. Who will take care of my child financially, legally? Who's going to have the authority to take care of my child? Where will he live? Who's going to pay for her therapy? How can I be sure that the money I leave for my son or my daughter will last, given his or her specific needs? We think we have to rethink the way that we plan. We have to rethink the way that we plan for ourselves, both from a legal and financial perspective. We have to think in a multi-generational way. I'm going to explore what that means during this talk, and I'm going to give you some specific steps that I think you should take right away while this is top of mind to build the foundation that will provide for a really amazing future, both for you and for future generations. And it's such a critical subject. It's such a scary subject, and it can be overwhelming. But again, I'm going to throw a lot at everybody, but I'm going to try to give you some action items at the end that you can just step into right away. So just really quickly, for people who don't know me, here's a little quick background on me. So I actually grew up in Palo Alto, California. My parents, Michael and Myra Gilfix, started the firm that I'm at, Gilfix and LaPole Associates, in 1983. They both were in the nonprofit world for 10 years before that. They both graduated from the Stanford Law School around 1973. My dad started the first free legal aid program for the elderly in America, Senior Adult Legal Assistance. He started one of the first free legal aid programs for Americans with disabilities in 1976, the Disability Law Center. So it really is a family legacy. But just about me, I went to Stanford University. I graduated with a degree in management science and engineering. I went into the management consulting world. I worked with big corporations on big corporate strategy issues. I worked in the venture capital world. But after that, I went back to the Loyola Law School. I did that as an evening student while I was working. Not a fun 4 years, but I got through it. And since I graduated from law school, I try to get out there. I do a lot of writing and speaking. It's something I'm passionate about. I have the best mentors on earth in this area of special needs planning and long-term care planning. And I'm passionate about educating families and helping them to understand what's out there and the tools that are really available for all of us. I'm on the board of the Pacific Autism Center for Education, Bay Area Housing Corporation. These are two amazing nonprofits that are focused on the needs of adults and children on the autism spectrum. I do a weekly radio segment on 1310 a.m. here in the Bay Area. So I like to get out there and educate. So that's me. Really quick fun aside, I was also a professional actor. I lived in Los Angeles when I was a management consultant. If you were familiar with the introduction of Siri, you probably saw me in one of Apple's promo videos because I was the face, one of the faces of Siri. So this was literally the image that was on the iPhone homepage for like 6 months, and I was in the introduction commercials and all that, introducing Siri to America. It was the iPhone 4S, and I apologize that Siri still doesn't work very well, but I was just helping introduce it. I didn't design it. Again, about our firm, Gilfix, we've been in Palo Alto for over 35 years at this point. We believe we're the second firm in the state of California to do special needs trusts. So this is deeply a part of our history. Some of the topics that I'm going to go through, and it's a lot, but I promise I'm going to try to break it down in plain English. I'm going to talk about the ABLE Act. That's a critical new tool that I think many of you may have heard of. If you haven't, it's important that you're at least aware of it and how it works. I'm going to talk briefly about government benefits that are available to adults who are classified as being disabled, quote unquote, and I'll talk about what that even means. How does the law determine if someone is disabled in the eyes of the law? I'm going to talk about the most important tool out there, which is a special needs trust, what it is, how it works, and how to fund it. I'm also going to talk about what that number is. When I say that, the number means how much do you need to leave for the benefit of your child with special needs to be sure that he or she will be covered long into the future. How can you think about that, and how can you make sure there's enough there? I'm also then going to talk about how this can come together with your own planning, with other family members' planning in a multi-generational way, and what you have to think about, and then some steps you have to take right now. And this is really all about creating a lifelong financial and legal safety net for your child with special needs. A lot, I know, but we're gonna dive right in. Another line I think many people can relate to: a diagnosis changes everything. When you hear that someone in your family has special needs, whether it's being on the autism spectrum, a learning disability, a physical disability, anything, instantly your life changes. And you have to marshal your resources. You have to learn about this whole new area of planning. How are you going to support your child? How are you going to make sure that they're safe? How are you going to make sure they're cared for long term? How are you going to make sure they get the best possible care, education, services? It's a big issue, and it is not uncommon. The latest statistics, and many in the audience here might even have more up-to-date statistics. The last that I saw were that 1 in 59 children is on the autism spectrum, and that number has been going up and up and up over the years. I know there's a lot of debate as to why that is, but the fact is there are a lot of children on the autism spectrum, and that's just the autism spectrum. There are other issues that obviously require special help, and the problem is all of these compete for the same scarce government resources. And so as the number of kids on the autism spectrum goes up, and as the number of people with general disabilities or with special needs, as those numbers go up and up, we're not seeing a massive increase in government funding. And you look at the government budget deficit issues that we see, I don't think government programs are going to get much better going into the future. So what does that mean? There's a bigger and bigger gap between what's available from government resources and the need for these limited resources. So how can you help fill that gap? How can you make sure that your family, your special loved one, is cared for? Well, one tool that's really important to understand is the ABLE Act. So this was, many of you may be familiar with this. This was Achieving a Better Life Experience. It was actually passed in 2014. The ABLE Act allows you to create an account of a limited amount for a child or adult on the special needs spectrum who is qualified as being, again, quote unquote, disabled. And you can put up to $15,000 per year into one of these accounts. That's a strict limit. You can't put more than $15,000 a year, and they can hold up to $100,000. Now, what is the benefit of an ABLE Act account? Well, one, money in an ABLE Act account grows tax-free. It's kind of like a 529 plan. That's what you put money aside for your child's college education. Money can grow tax-free. ABLE Act accounts are similar. Money can grow tax-free. And very importantly, funds in an ABLE Act account do not count as belonging to the beneficiary, the child with special needs, when it comes to government benefits eligibility. I'm going to talk more about that, but the point here is you can have up to $100,000 in an ABLE Act account. The person with special needs or person on the autism spectrum who the money is set aside for, they can actually manage this money if they're capable of doing that, and they can use the money for their own personal needs. And these accounts can hold up to $100,000 over time, and they don't have to report this as belonging to them if they're trying to become eligible for SSI or Medicaid, Medi-Cal, or other needs-based government programs. I'm going to talk about what those programs are in a second, but it's a great tool, and it's a way that money can be set aside and managed and spent by someone with special needs without making them ineligible for government benefits. Now, this is great, but the limits are pretty strict, so it's not a catch-all. It doesn't solve all the issues we face long-term, but it's an excellent tool that you should be aware of. They are in place in California. I think it's just calable.org or calable.gov. Very easy to Google information about this, and it's not that hard to set these up. You don't need a lawyer to do that, but it's important to be aware of these, but they do not mitigate the need for a more comprehensive plan. So just really quickly about some government benefit programs of which we should be aware. There's more out there. I'm not intending this to be comprehensive, but there's a few programs that are needs-based, meaning you have to report how much you have in the way of assets in order to become eligible. You have to be below very low asset limits to get these benefits. But there's other programs that don't care about your assets. They're just more based on money you put into the system or earning you had into the Social Security system. So SSDI, Social Security Disability Insurance, SSI, Supplemental Security Income, Medicare, Medicaid, or as we call it here in California, Medi-Cal. There's a bunch of other programs, including IHSS and Home Support Services, Section 8 housing. Some of these programs are of very limited use. Section 8 housing, you may know, has like a 8 or 10 year waiting list, and it's really hard to find housing, but it can help pay for housing if you're eligible for that. SSDI, Social Security Disability Insurance, is not needs-based. It is based on money you put into the Social Security system, how many quarters you worked. And if you have a disability later, you can get SSDI. So Bill Gates, when he was younger, could have gotten SSDI because he paid into the system. If he had become disabled, he could have gotten it. He could not, however, have gotten SSI or Medicaid, Medi-Cal. Those are needs-based programs. You have to report to the eligibility workers how much you have in the bank in your name. And if you're over $2,000, broadly speaking, there's some other exceptions to this, but if you're over $2,000, you don't get this. ABLE Act account funds, again, don't count against these limits. So important to be aware of these programs, and important to create a plan that doesn't interfere with your child's ability to get these down the road. And there are ways to do that. You can set aside even millions of dollars, and your child still could be eligible for the needs-based programs, SSI and Medicaid, most notably. Now, what do we mean by disability when it comes to qualifying for public benefits? I know a lot of parents that I work with, their child is on the autism spectrum, but if you looked at Silicon Valley companies, I would bet a lot of the very best programmers at Facebook, at Google, at all these top tech companies, I would bet a lot of them are actually on the autism spectrum. I think it's such a broad spectrum, and there's no one size fits all definition of what it means. So a lot of parents say, well, I'm worried about my son, but he might actually be able to work and earn a lot of money in the future. I just don't know. So what does that mean in the context of government benefits and how the government looks at disability? Well, the government doesn't really care what the cause of the issue is. It really goes down to one's ability to maintain substantial gainful employment. If for some reason you cannot maintain substantial gainful employment because of some condition or some disability or some mental issue that you have, then you are likely deemed to be disabled in the eyes of the law and therefore can qualify for disability-based benefits. It does not mean that you don't have capacity. It doesn't mean that you're not intelligent. It doesn't mean you can't make decisions for yourself. It just means that for some reason you can't maintain substantial gainful employment, full-time employment, in order to pay all your bills. So you need some assistance because of something that's likely out of your control, although even drug addiction and alcoholism can sometimes be deemed to cause a disability. So it's a pretty wide definition, but I think most importantly, I want to make sure there's no stigma with that. Just because you're called disabled in the eyes of the law does not mean that you are less than somebody else. It does not mean that you're not intelligent. It does not mean that you cannot make decisions for yourself. That's really important. So I want to make sure people don't see that as a negative term in this context. It just means you have trouble supporting yourself. And again, in most cases, to qualify for public benefits, you typically have to have less than $2,000 in countable assets. Now, if you're receiving government benefits, can you still work? Yes, There are a number of programs that allow someone who's receiving these needs-based programs to still maintain some type of employment. So I want to make it clear that if you're getting these benefits, it doesn't mean you have to just sit at home and not leave and not work and not get out in the community. You absolutely still can. You just have to be a little bit careful with the types of programs and the types of work that you take. This is kind of a side note, but I think it's important. So the Affordable Care Act, or AKA Obamacare, it allowed a lot of people to get medical insurance to pay for some medical needs that in a way that's easier than it used to be. But the problem is there's so much uncertainty about this program. Are there enough doctors who will participate in this going forward? Is there enough capacity to meet the need of people who get this type of insurance? And who knows what's going to happen in the future? I mean, we have a little election happening in November. Depending on what happens there could be massive changes in the possibility of getting insurance through the government and what types of health insurance will be available in the future. So again, just lots of uncertainty with regards to insurance, with regards to government benefits, with regards to what's going to be available to support children and adults on the autism spectrum. So what can you do to future-proof your plan and to make sure that you, as a parent or a grandparent or aunt or uncle, are doing everything that you can to protect that child with special needs long into the future? Well, if there's someone who you deeply care about and you want to support in the future, the most important document you will ever create will be a special needs trust for that individual. Now, what is a special needs trust? It's a special trust, as it says. It's an irrevocable trust designed to hold assets for the benefit of a disabled person or a person with disabilities without disturbing eligibility for public benefits. That's the main point of this. It has to be irrevocable. But a special needs trust can hold $10,000, it can hold $100,000, it can hold $10 million. And if it's properly set up and properly administered, the money in that trust does not count as belonging to the beneficiary, the person it's there to support. And why is that important? Well, SSI, Medicaid, Medi-Cal, making sure that that individual can still get these important government benefits, because over time, the costs can add up massively. So getting even small government benefits every month can make a huge difference in one's long-term care and their financial stability. So in a way, setting up a special needs trust, you can have your cake and eat it too. You can leave a bunch of money for the benefit of someone you care about, and they can still get government benefits. So you're not interfering with that. And very importantly, a special needs trust also means that you're naming a trustee, a third party who manages and oversees these assets for the beneficiary, the person who's getting the benefit of this money. And that's actually a really challenging issue. I give whole talks about how you choose your trustee, but you have to think long into the future. If you're planning for someone who's now 20 years old and you're in your 50s, well, you're not going to be around. And after you're gone, that's typically when special needs trusts are funded. When parents are still around, parents serve this role. The special needs trust is there to step in when you step out. When you pass away, the special needs trust is there to take your place from a financial perspective. And you have to name a trustee who'd oversee that money, manage it, determine how money is to be spent for your child or your loved one. And that's a critical thing, and something you really need to think long and hard about. And it's something when I have meetings with clients, that's the biggest part of our discussion, is figuring that part of it out. But again, it's the best of both worlds. Money set aside for your child or your loved one, managed by someone you trust, and it doesn't interfere with government benefits as long as it's set up properly and administered properly. I get this question all the time. Hey, I have 2 kids. My son's on the autism spectrum. My daughter's doing really well. I'm worried about my son. I don't think he can manage money. Why don't I just leave money to my daughter and she can just take care of him after I'm gone? Do not do that. Just don't do it. There are a number of reasons why it just doesn't make sense. First of which is, what if your daughter gets sued in the future? What if she gets a divorce? The money you leave her could be lost. It's exposed to her creditors, to her risks, to her spouse's risks. A lot of bad things can happen to money that's not protected. Another thing, what if your daughter has financial issues of her own in the future, and all of a sudden she doesn't have enough to support her own family? That money that you left her, where she promised she would use to support her brother with special needs, well, now she has to make a tough decision between taking care of her kids or taking care of her brother. And that can breed resentment, that can breed issues, that can breed all kinds of problems. So a special needs trust can solve this, because there's no choice to be made. the money you leave for your child with special needs is only available for that child. There's no conflict. There's no issue where if your other child, if their sibling gets sued or gets a divorce, that money is not going to be lost. It's going to be safe, and it's going to be there for the child or the adult with special needs. So the primary type of trust we're talking, there's two types of special needs trust. There's third party and there's first party. And the third party, first party just refers to the source of funds, where the money came from. The most common type of trust, the one that you would set up for someone else, for your child, is a third party special needs trust, because the money for the trust came from a third party source. This is usually a parent setting it up for a child. So mom and dad are worried about their son or their daughter, and so they say, hey, as part of their estate plan, I'll talk about how this all fits together in a moment. As part of their estate plan, their living trust, and you should have a living trust, says when I pass away, money's not going to my son John who has autism. It's going to go to the trust that we set up for his benefit, John's special needs trust. Usually it is funded when mom and dad pass away, but there are reasons why you might put money into it ahead of time. Other relatives can contribute to it. The key is John can't put his own money into it. It has to come from third-party sources. Currently, you can pass up to $11.58 million per person without any estate or gift taxes. So between a couple, you can pass over $23 million to a special needs trust or to all of your kids combined without a penny of estate or gift taxes. So it's a good problem to have if you're over that limit. But my main point here is don't worry about estate taxes. Unless you have a very large estate, you can leave a large amount of money in one of these trusts with really minimal tax issues. It can also, the source of the funds can be anybody other than the beneficiary, him or herself. It could be a grandparent, it could be an aunt, it could be an uncle, it could be a sibling. And this is where coordinating across generations can be so critical. So often, I will work with clients, and sometimes they created an estate plan a few years ago, and their trust says, well, when I pass away, my trust becomes a special needs trust for my son, and I'm going to leave X dollars to that. I do not recommend that approach. A trust should be a separate standalone document that you create from day one. Now, why is that? What if other people in your family want to leave assets for the benefit of your son? If the special needs trust only begins to exist when you pass away, there's nothing for them to leave money to. If you need to do tax or long-term care planning down the road, there are often situations where it makes sense to transfer money to your child's special needs trust while you're still around. You can't do that if the trust doesn't exist yet. So it's critical that you set it up as a standalone, separate document, separate trust from day one when you create your plan. And that way we can coordinate with other members of your family. We can make sure that their estate plans are up to date and they are leaving money to the special needs trust, not to your son or daughter directly if they want to help them out. Now, another type of trust, and this is where planning wasn't done properly ahead of time, we can still protect money. A first-party special needs trust is a trust where an individual with a disability sets up a trust for themselves. So they take their own money and they say, well, I'm not eligible for government benefits. What can I do to put this money aside and become eligible for benefits again? Well, they can set up their own trust, their own first-party trust. In other words, the money came from the first-party source, the beneficiary, him or herself. You have to be disabled. You have to be under 65. And so you can put your own money aside into a special needs trust. The problem is with a third-party trust, the one I just talked about, when the beneficiary passes away, the trust says where the money goes. It often will go back to other family members. If the beneficiary has children of his or her own, they can go to those kids. The state cannot touch that. A first-party trust, the state gets paid back. So the state basically makes a deal. They say, okay, well, you have a disability. We'll let you put your money aside and we'll give you government benefits. But because that was your money and you're kind of putting aside, we're giving you a break. But when you pass away, we get first dibs on getting paid back. So if there's any money left in that trust, before it goes to your family, before it goes to your kids, the state of California gets paid back for all those benefits we paid you during your life. So we would much rather create third-party trusts with other sources. We don't want to accidentally leave money to an individual with a disability and have them put into a trust, because in the state of California, you can get that money when they die. We'd much rather keep it in the family, and that's a third-party trust, and that's 90% of the time what's there if we plan ahead. Again, I talked about who can fund these trusts. It's not just parents for their children. It can be siblings setting up for their brother or their sister. It can be grandparents or godparents. It can be anybody other than the individual with a disability, him or herself. Anybody can leave money to a third party special needs trust really for anybody else. And that's where coordinating within a family is so, so, so important. There's so many incredible things we can do if we leverage that and if we talk to each other. So I think that's a really important point. You might think, well, I don't think I can leave enough for my child. What am I going to do? Well, talk to other family members. There may be ways to leverage what they want to leave to your child in really powerful ways. And I'll talk about ways we can leverage that, leverage potentially smaller amounts of money to create big benefits down the road. I also get this question a lot. What if my child can work down the road? That, I think my son I don't think he'll be able to work, but, he's doing better in school, maybe with some additional therapy or educational, maybe he'll be able to work. Maybe he'll be able to get a great job. Maybe he'll become one of Silicon Valley's top programmers. You just don't know what the future is. Should I still set up a special needs trust? When in doubt, you absolutely should set up a special needs trust. Now, the reason is if your child has trouble in the future and can't work, well, the special needs trust is a lifesaver. They can still get government benefits. The money in the trust is still available to support them. If they can work and they don't need government benefits, the special needs trust isn't that bad. It's still there for them. So one thing is, for some clients, we put in provisions that say, hey, if my child has maintained gainful employment for 2 straight years and doesn't need government benefits, and according to his primary doctors or caregivers is going to be good long into the future, well, then you have the right to terminate this trust and just give the money to my son directly. Another thing, though, rather than terminating the trust, your child's doing well, the trust can just still continue for him. And the trustee who manages the assets for him can just pretty freely distribute money from the trust without worrying about government benefits. They can just start giving out large amounts of money each month to support your child. So my main point here is, when in doubt, create the special needs trust. There are a number of ways it can still be helpful to your child, even if they don't really need it, if they don't need government benefits. But if they don't have a special needs trust and they need it, that's a problem. And also, as you see your child grow up, even if you set up a special needs trust now, maybe you observe how he or she's doing 10 years, 20 years from now, you change your plan down the road. But we want to be ready if, God forbid, you get hit by a bus and your child can't work and you don't have time to change, or nobody's around to change your plan as they see things change. We want to make sure that worst case scenario is covered. So when in doubt, create that extraordinarily powerful special needs trust. What can a special needs trust pay for? It is not restricted as much as you might think. A special needs trust can pay for entertainment, it can pay for cars, it can pay for clothing, it can pay for food and shelter. Sometimes people think, well, if the trust is paying for food and shelter, my child can't get SSI or other government benefits. That's wrong. They still can. They just get reduced a little bit. It can pay for furniture. It can pay for fun things like video game systems. It can pay for vacations. It can pay for all kinds of expenses you might not think a trust could cover. One question that I get all the time too: can special needs trust funds be used to pay for Britney Spears concert tickets? Yes, they can. This is actually an older case. I know Britney Spears is not quite as relevant as she was many years ago, but there's actually a court case where this was tested, where a special needs trust funds were used to pay for Britney Spears concert tickets because the beneficiary loved Britney Spears. And the state said, hey, whoa, you can't use money for that and still get government benefits. That's the violation. And the court said, no, that is a quality of life thing. It's okay if a special needs trust pays for Britney Spears concert tickets. You can still get government benefits. That is okay. So I don't really agree with Britney Spears concert tickets being a good expense. I'm just not a fan. But my point here is special needs trusts are not as restrictive as they might sound. When we talk about irrevocable trust, I think a lot of people start to feel intimidated. They start to feel like, oh my gosh, this is super intense. The money won't be really available for my son or my daughter. It's going to be only available for very specific categories of expenses. It's going to be a huge pain for someone to manage. Not really the case. It's a lot more flexible than you might think. On a related note, another one of the biggest fears that we hear about is homelessness. If you look at the population of Americans who experience homelessness, a high percentage of them have mental illness or other special needs issues, and they just don't get help. And as a result, they don't have a roof over their head. And in the Bay Area, that's especially acute because housing is extraordinarily expensive. I mean, it's insane how much it costs. The cheapest single-family home in the Bay Area is like $1 million. The cheapest rent you can find for a studio apartment $1,800, $2,000 a month. What can you do to prevent this for your child, assuming that worst case scenario? Well, again, special needs trust is the key. It absolutely can pay for housing. It can own property that your child can live in. It can own property that if it doesn't make sense for your child to live there, the trustee can rent that property out and use the rental income to pay for a different place for your child to live. The key is a special needs trust absolutely can provide housing for the beneficiary, for the child or the adult with special needs. So a critical thing, and we've had clients who leave houses to special needs trusts, who leave condos or rental properties, if you're lucky enough to have that. They aren't limited in the types of assets they can hold. They can hold investment accounts, they can hold retirement accounts. I'll talk about that in a minute. They can hold cash, but they absolutely also can hold property. Now, when you leave property to a special needs trust, you have to make sure there's enough other funds to pay for maintenance and taxes and all that. But absolutely, you can leave virtually any category of assets to a special needs trust. Another key issue, how much is enough? How much do I need to leave to a special needs trust to be sure there's going to be enough to support my child long into the future, as long as he or she is going to need it? The quick answer is as much as you can afford. Obviously, the more is better, but that's not possible for most families. Most families don't have unlimited resources. How can you calculate what is going to be needed, and how can you fund it? What are some creative ways to put more money away for a special needs trust than you might think is available right now? How can you provide that safety net? The question, is $1 million enough? How can I guarantee that there's going to be something there if I have my own expenses? A big part of what I do is, in addition to special needs planning, is long-term care planning. What if you as a parent need your own long-term care? What if you have to go to a nursing home later in life? What can we do to protect your assets and pay for your long-term care and still ensure that there's going to be money left or money available for the special needs trust and for your child on the autism spectrum if he or she can't work? One really powerful tool is life insurance. So this is a big part of special needs planning, and it is a way that you can leverage likely a much smaller amount of money than you think to guarantee a pretty large payout in the future for a special needs trust. And you absolutely can name a special needs trust as the beneficiary of a life insurance policy. You can say, hey, I'm going to buy this policy. When I pass away, you can absolutely say the money goes not to your child, but goes to a special needs trust. And that can be an extraordinary thing. We've had clients who were terrified of the idea that they wouldn't have enough, or that they wouldn't be able to leave any money for their other kids because they're going to have to leave everything to the special needs trust for their child who needed it. There are ways that we can leverage, again, seemingly small amounts of money to create big impacts down the road. So here's one example. We work with a life insurance expert who really specializes in this area. And this was a couple. Husband was 48 years old, wife was 45 years old, and they purchased a second to die policy with $1 million payout. So this was an insurance policy that when the second spouse, when dad, not when the first spouse passed away, but when both mom and dad passed away, only then on the second death would money go into a special needs trust. This was $1 million. You might think that's a lot of money. I need to put away hundreds of thousands of dollars to guarantee that. Not the case. If you're young enough and if you can pass a physical, and even if you're older, the numbers get bigger, but they don't get necessarily astronomically bigger. But this couple had two options when they worked with a life insurance expert. They were able to get $1 million in coverage with one payment of $60,000. One time, that's it. They never had to make another payment. So $60,000 is a lot of money, but when you're looking at a future of $1 million guaranteed, that's a pretty good investment to guarantee that. They also had the option of making lifetime payments of about $4,300. So they have to keep paying that every year to get this $1 million. So it was an option. Either I can pay $60,000 today and I'm done, insurance is guaranteed, or I can pay $4,300 a year indefinitely, and this $1 million would be guaranteed. Now, even $60,000 can seem like a lot, but this is where multi-generational planning can be so powerful. You get grandma and grandpa in the picture, or aunt and uncle who want to help out. And maybe they don't really know how to do it. Well, they can help contribute to this. Maybe grandma and grandpa contribute $20,000, $40,000 to this. not that big a gift. You don't have to be high net worth to afford something like this, but they can leverage that $20,000 or $40,000 or $60,000 gift into a guaranteed $1 million for your child. That's just one of many examples of where if you plan ahead, create your own estate plan, create the special needs trust ahead of time, and really coordinate your financial, legal, and insurance planning, where we can do extraordinary things. And part of that is really talking to other family members and communicating about this. So we've seen life insurance, it's kind of a dry subject, but it's worked wonders in giving our clients peace of mind in knowing that there's going to be a good safety net there in a special needs trust. Retirement accounts, IRAs, 401ks, these also can be left to a special needs trust. You can absolutely, this would be your beneficiary designation. So typically when you have a retirement account, you name your husband or your wife as a beneficiary. If not, you name your kids. You absolutely can name a special needs trust as the beneficiary of a retirement account. And recently you may have heard about, there was a new law that passed, the Secure Act. It changed the way that retirement accounts are governed and how they're taxed. The big takeaway, it used to be that if you left a retirement account to your child when you passed away, their RMDs, required minimum distributions, the amount they had to take out each year was based on their age. So if your child was 40 and you left them $100,000 to your IRA, they could stretch out. The IRS would say, you're 40 years old, we think you're going to live another 40 years. You can take out 1/40th of that retirement account each year, and that's okay. You don't have to take more than that. And that you typically want to spread out distributions from retirement accounts over time, because you have to pay income tax as you take money out. You don't want to have to take it out too quickly. That changed. You no longer can stretch it out over a long period of time. Most people now have to take out inherited IRAs within 10 years of inheriting them. Not a huge deal, but it means you're going to be paying more income taxes. However, there is an exception. If you leave a retirement account to an individual with a disability, they don't have this 10-year limit. They can stretch the retirement account out longer. So they can take out smaller amounts each year, pay less taxes over time. We believe that special needs trusts will also meet this exemption, that if you leave a retirement account to a special needs trust, the money won't have to be taken out within 10 years, that we can extend that to the life expectancy of the person for whom the trust is set up. Without getting the details here, the bottom line is it may be a really good idea to actually leave more of your retirement account to a special needs trust than to other kids who don't have a disability. There's exceptions that make this beneficial from a tax perspective. Again, that's not the focus of my talk, but it's another area where coordinating your financial planning and your tax planning, your legal planning is so important. Just making sure you're doing everything right, because making a bunch of smaller right decisions can add up to hundreds of thousands of dollars in tax savings and government benefits savings down the road. Other assets, I mentioned this before, you can leave really anything, virtually anything, to a special needs trust. Investments, stocks, bonds, property, cash, of course. Life insurance policies can go to a special needs trust. And when you pass away, you get a step up in cost basis, meaning if you bought a property for $100,000 many years ago and now it's worth $1 million, well, if you were to sell that, you have a $900,000 gain. $1 million that you sell it for minus $100,000 that you paid for it. That $900,000 gain is taxed pretty heavily. You have to lose up to 33% of that in state and federal capital gains taxes. So you could lose over $250,000 in taxes. When you pass away and assets go to a special needs trust, that gain vanishes. There's a step up in cost basis. So the IRS says, I don't care what mom and dad paid for this house, whatever it's worth on the date of death, that's what I'm going to use to calculate future capital gains taxes. So in other words, you spent $100,000 on a house. If you were to sell it for $1 million, you'd owe $250,000, $260,000 in capital gains taxes. If when you pass away, you leave it to a special needs trust, the trustee of that special needs trust could later sell it for $1 million and pay zero in capital gains taxes, because the IRS resets that cost basis, that number they use to calculate gains, to the fair market value on the date of death. So again, this is critical when you're thinking about how all your planning fits together. Now I want to talk just about how you can build a great team to coordinate all this and to bring this all together. I do recommend that anybody, especially with a child with special needs, has a team of advisors. And by that, I mean financial advisor, legal advisor, and ideally they work together. In some cases, can be the same person. It depends on regulations and who you're working with. But you need someone who understands the complete picture. You don't want someone who's just going to put your money in a couple index funds and say, okay, well, this is generally how we do things for someone of your age. That's not a bad thing, by the way, but you need to think beyond this. You need to make sure that you begin with the end in mind, that you need to make sure there's going to be enough there to fund the special needs trust that you need to create for your child. And you need to understand how this all fits together. And ideally, your plan should think long into the future in a way where only interest and dividends, not principal, are used to support your child. I'll go into what that means in a second. You don't want to have to be digging in to trust assets where the value of your trust is going down each year. That means it's going to run out eventually. Ideally, you set it up with enough money where your child will have his or her expenses covered with just income and dividends and sustainable growth covering all the expenses, where the value of the assets in the trust doesn't significantly shrink over time, because that way it's sustainable forever. If you're digging into the trust principal, then eventually you're going to run out of money. I'll give an example of what this means. And again, for financial advisors, you got to make sure they're a fiduciary, that they put your interests over their own, that they're not charging double fees. So a lot of financial advisors will charge an annual management fee of 1% or maybe a little bit less, but they shouldn't also be charging commissions on buying and selling financial products for you. It should be one or the other. It shouldn't be both. They should have experience with special needs planning and ideally long-term care planning for you as well. They should work closely with your attorney or your estate planner to make sure everything's integrated, because your legal planning should be integrated with your financial planning. They should know the structure that you have in place. They should know the types of trust you're putting into place, and they should be aware of how this all fits together. Again, we are trying to, our team at my firm, Gilfix and Lopole Associates, we're trying to actually build an active network of financial advisors who we want to work with on a more formal basis, because we've seen how much more powerful planning can be when everybody's on the same page, everybody's communicating and working together. You absolutely do not want to put your money just in the bank. I know it seems safe. I know, by the way, the market is down like 10% in the last 3 days. It's a scary time. There's always going to be corrections. That's just how the stock market works. There's ups and there's downs, and the downs are really, really scary. But sometimes having a financial advisor and a team of people you're working with, a good estate planning attorney, a good legal advisor, a good financial advisor, these are the people you should go to when you're freaking out and you're thinking, oh my God, I want to pull all my money out of the market. Because typically, historically, the worst thing you can do is to pull your money out of the market right when there's a mini crash or a correction. Over time, the stock market has always done pretty well. If you spread out your time horizon enough, the stock market does really, really well. Over a short time horizon, there are some rough stretches. And that's where having the right mix of equities, of bonds, of fixed income investments is key. You want to be in a position when the market goes up that you're benefiting from that. But when the market goes down, you want to have some safe harbor investments that don't get hit as hard. You do not want to just put your money in the bank and let it grow at 1% a year if they're even giving you that. Then you're not even keeping up with inflation, and you're going to fall behind over time. So the bottom line is you need to coordinate all of this. And again, coordinate with grandparents, with aunts, with uncles. Talk to your family. Can people work together to create a safety net? I talked about how grandma and grandpa can purchase life insurance for mom and dad. We had a very real example of that, where some of our clients, we told them, hey, bring in your parents. Let's talk about how we can integrate their plan with yours. And when the idea of life insurance came up, it was this extraordinary moment when grandma and grandpa realized, hey, we can just make a gift of $50,000 to purchase a life insurance policy that will pay out $1 million for our child with special needs. Because they had thought, oh my gosh, we just don't have enough. We can't give enough to make a real difference. And this was a way that they knew they could make a big difference. That's one of many, many other examples. If there's any aunts or uncles, especially who don't have kids in your family, or cousins who just really want to help out down the road, again, there are ways they can leverage small gifts into something big, or at least make sure that anything they want to leave to your child goes to a special needs trust and not to that child directly. So again, coordinating planning across the family, across generations, integrating legal and financial advisory services, all of this, the more you communicate, the more you bring your team together, the more powerful this can be and the more peace of mind you're going to get. How much? Back to that question I asked before. How much is enough? How much do I need to leave for my child to make sure there's enough there? Think retirement. So generally speaking, and 3.5 to 4% returns are pretty, you can rely on that. And that should be, according to most studies that I've read, that should be sustainable over time. Now, what does that mean? So let's say you put $1 million into a special needs trust. If it's properly invested, even conservatively, you should be able to count on taking about 4% of that out, about $40,000 per year, without that $1 million really going down, without accessing the principal. So the 40K, the 4% return, that's the income it's producing. The 1 million is the principal. Ideally, you don't want to have to dip into the principal. You want to rely just on income. And if it's properly invested over time, there'll be up years and down years, but over time, it should be pretty safe to take about 3.5% to 4% out per year. So then you think backwards. Okay, well, I think I'm going to need about $3,000 a month to support my child in addition to government benefits. That means about $36,000 a year. Back into that. Okay, how much money do I need to put in my trust to guarantee a 3.5 to 4% return that will give me $36,000 per year? It'd be about $1 million. So the numbers do get pretty big, but there are ways we can calculate and do our best to plan for what we need. And that can inform the types of insurance we get. That can inform the type of financial planning that we need to do and how you need to organize your finances today to make sure there's enough there down the road for your child. But every child is different. Every child has different needs and will need different benefits down the road. So there's no generalizations I can make. Obviously, more money is better than less. But the key is communicating and thinking about this and talking to your team. There are a lot of different ways that we can plan ahead. I always strongly advise that you create what we call a letter of guidance as part of your plan. This is just something you give to future trustees or caregivers to say, this is what my child likes, this is what they don't like, this is how I'd like money in the special needs trust to be spent for my child. We've had clients say, hey, my son loves skateboards. I don't care how old he is. I always want to make sure that trustee knows you should buy him the best, latest skateboard deck and wheels or whatever, or the best video game system. I want him to have that great video game chair and the haptic sensors and all this stuff. He cares about that. I want money to be used for that from the special needs trust. It's a critical but really cool part of the planning process. You don't need a lawyer or anything like this to do this. As we get towards the end of this talk, I want to also just revisit, what does your estate plan need? This is one of the key things that if you are thinking, well, I did an estate plan, you may need to revisit this. If you do not have an estate plan, you need to do it immediately. It's so critical, but it will be so beneficial for you and your family. 3 core documents that you need, mom and dad: revocable living trust, a comprehensive durable power of attorney, one that you do with an attorney, not just check the boxes. There are a lot of reasons why we need to include some special provisions in that to make sure a special needs child is covered, and advanced healthcare directive. The trust governs where your assets go after you're gone, and it avoids court. A durable power of attorney governs your day-to-day financial affairs if you become incapacitated in the future. Let's say you're in an accident or in the hospital. Who can manage your bills? Who can pay your taxes? Who can coordinate your planning with a special needs trust for your child? Power of attorney authorizes someone to do that. The advanced directive goes to your own healthcare and your own medical decision making. And of course, as part of this, you also need to create a special needs trust for your child. So your living trust would say, let's say you have 3 kids. Well, 2 of my kids, I'm leaving assets directly to them or in different types of trust. But for my child with special needs, that share of my estate goes to the special needs trust that I created for that child. I'm not going to spend much time on this, but long-term care, when we're talking about multi-generational planning, well, all of this planning is great, but what if you, mom and dad, need very expensive long-term care? 70% of Americans will need some form of long-term care. This can be really, really expensive. How do you plan ahead for this? Well, you might look at long-term care insurance. There are hybrid life and long-term care policies where if you need long-term care, the policy will pay for that. If you don't need long-term care, there's a death benefit that will go to the special needs trust. Medi-Cal, we talked about in the context of a child with disabilities. Medi-Cal can also pay for long-term care in a skilled nursing facility, and there are all sorts of steps we can take to protect your assets and help you become eligible for Medi-Cal while transferring assets to the special needs trust ahead of time or preserving assets within your family. That's a big part of what our firm does. And again, a good team, financial advisors, legal advisors can help you navigate this. And if you have parents who are dealing with long-term care, it is critical that you talk to an estate planning attorney or someone who really knows what they're doing in this space to protect their assets, because they can transfer assets to you or to a special needs trust and get help from the government sooner rather than waiting until they're broke. If you want to learn more about how some of this long-term care stuff fits in to this multi-generational planning, our website, Gilfix.com, there's a couple articles that I've co-authored with my father. We co-authored a book called Facing the Reality of Long-Term Care. We also wrote a book about special needs trust that we actually just updated. We're going to have a new version of it. It's called Special Needs Trust Creation and Management Guide. Very creative, I know, very sexy. So Our website has some resources. Obviously, the Autism Society has some amazing resources as well. But that's how you can see some more illustrations of what I'm talking about. Now, also, what does your child need? This is getting into some other subjects, but when your child turns 18, special needs or not, your child should sign a durable power of attorney, an advanced healthcare directive, a nomination of the conservator, and ideally a will as well. But these are ways where your child can voluntarily give you the ability to help him or her out without getting a conservatorship, without going to court. Our firm is a big believer that whenever possible, individuals should retain their own decision-making rights, and that we should stay out of courts whenever possible. And doing these documents ahead of time can be a very powerful way to do that. So some steps you should take right now. What can you do? I've thrown so much at you. I understand if your head is spinning just a little bit. I think the key message I want you to come away with is that there are resources out there. There are people and teams who can help you. First step, update your estate plan. Make sure even if you did a special needs trust before, make sure it's revisited by an expert. And if you don't have a special needs trust, if you don't have your own estate plan, that's step one. Get your own estate plan into place. Ideal with someone who specializes in this area. Make sure you set up a separate special needs trust for your child who has a disability. Then the next step is revisiting all this in the context of your financial planning. If you don't have a financial advisor, that's okay. Hopefully your attorney who you work with can help connect you with someone, or even your attorney might be able to help you develop a mindset around that. But you need to rethink your financial plan to make sure you're taking this long-term approach into account. And you may want to look at life insurance as well as part of this. This is an opportunity. While all these, whether you're listening live or if you're listening recording of this, while this is top of mind, you are thinking about this, you are fired up, you are energized. Hopefully this gives you some idea about all the incredible tools out there. Do not let this opportunity slip away. The longer you go without taking action after this, the more you'll get overwhelmed with the minutia of day-to-day life, with your taxes, with paying bills, and this will fade. There is no benefit to waiting to creating a good estate plan. You get that into place, and you have put in an amazing foundation that will serve you and your family for decades. And yeah, you'll probably update it, but just take that first step. Go to work with somebody who can help you with this. It is so, so powerful. It's the best money you will ever spend when you start this process. I cannot tell you how many clients, when they sign that special needs trust in our office, they have tears of joy because they are so relieved to know they did something. It's something that you can control your future. The world is chaotic. We see the stock market today down 10% over the last week. Who knows what's going to happen in the next elections? Who knows what's going to happen with the coronavirus? Who knows what's going to happen with government benefits? But this is an area where you can take control. So I urge you to do that.
Hey, Mark,
I want to thank you.
A veritable blizzard of questions for you.
Okay.
So this is
yeah.
what we're going to do. I'm going to read one, and then Fada's going to read one. But after each question, I'm going to ask you to answer in as concise a way as you can. Okay, and we will run late. Hey, everybody, all you listeners out there, we will run late. So this will not end at 12 noon. Okay, sorry, Mark.
Yes, I'm happy to.
Billable hours. Okay. So
no problem.
We recently received a bequest from a will for our son in the amount of $5,000. It is written with my name as custodian for my son. However, he is 19. Will we get tripped up if we create a CalAble account and deposit this $5,000 in it if it has his name on the ABLE account? Meaning it is written in a way that it will be seen as his asset by public benefits, like SSI.
Yeah, so that actually, I believe that should be okay. It's under the $15,000 a year limit. So whether it comes from your son directly or from you guys, once it goes to the ABLE Act account, that's okay. So I'm not aware of any issues with an individual putting his or her own money into an ABLE Act account if it's under $15,000. I would double check that. Also, sometimes if it's a smaller amount of money, they don't look that closely, frankly, at where it came from. So I suspect it shouldn't be an issue. I think an ABLE Act account is a great choice for that. If it's still under your control, I would probably just set up that account and put it in there. I can't guarantee that you wouldn't have issues with government benefits eligibility. I don't think it would be an issue. So I think the CalAble Act, an ABLE Act account could be great for that. So I would encourage putting it into an account right away.
Well, we've received several of these questions. So the top question is, do you have availability and are you guys taking clients?
So absolutely, we do. I'm out of town a little bit the next in April, but yeah, we do have availability. Obviously, thrilled to get the chance to work with people in our community. There's 3 other attorneys in my office, in addition to me, who work in this area. So you can contact our office. I don't mean this to just be a pitch for our office. Obviously, is what we do. It doesn't have to be with us. Anyone who really specializes in this. But yeah, absolutely, we would welcome the chance to get to work with you. And the information's here, gilfix.com. You can also follow me personally, stuff that I post and videos I post on Facebook, /Mark Gilfix. Become a fan, and you can ask me questions there. But yeah, absolutely, we'd be thrilled to get the chance to work with you.
Next, another ABLE question. Can we parents withdraw funds from an ABLE account for any reason? Obviously, it has to be related to a disability, right? And could we use that money to help purchase a home? Would that impinge on eligibility for government benefits?
Yeah, so ABLE Act, there aren't many restrictions on what money can be used for from an ABLE Act account. Now, purchasing real estate would be tricky. I wouldn't recommend that because you'd have to think about who's going to hold title for that real estate. Usually we want that to be a special needs trust if it's for that child, and then that gets into some complex issues. So I wouldn't recommend buying real estate with money in an ABLE Act account, but you can pay for virtually anything else. There are some exceptions for SSI. If someone's getting their food and shelter expenses covered from a third-party source, that reduces your SSI benefits. But if it comes from an ABLE Act account, there's an exception. So it doesn't reduce SSI benefits. So it can pay for rent, it can pay for food, it can pay for all kinds of things. Buying real estate would be dicey. We'd have to kind of explore that. So I wouldn't recommend just jumping into that.
All right, don't worry about it.
Yeah, not that you could buy any real estate in the Bay Area for
Anyway.
Right.
$1,000, but
Exactly.
yeah, it's an interesting question. Okay, the next one is that you mentioned the importance of trustees and executors, and are there professional trustees out there for people that don't have family members?
Yeah, excellent, great question. So the ideal trustee would be a very trusted family member who's super responsible, who knows your child, and who's around their age, so they're going to be there for the long term. But yeah, many families don't have that. And then so we do look to other family members, other close friends, and if you don't have anybody who you really feel great about, you do look to the world of professionals. So some banks have trust departments that provide trustee services for special needs trusts. There are professional fiduciaries out there who specialize in this. Occasionally, I or another attorney in our office will, but we have to limit that pretty strictly because it's a lot of time and a lot of work to do it. So that's often a big part of our discussion. And it's also tough because you have to think 5, 10, 20, 30 years in the future. So you don't have to have a perfect answer for it because you can have a succession plan. But yeah, there absolutely are professionals. It's not an easy question though, and it's something that a lot of people grapple with, and we try to just provide people with different options and ways of thinking about it. There isn't always a perfect answer, but having someone or some entity there is a lot better than not having a special needs trust. So don't let perfect be the enemy of good. You want to have a good special needs trust. It's okay if you don't have the perfect structure.
Yeah. Another ABLE account question. I set up a 529 plan, which I think, as most people know, is a college savings plan for my son before he was diagnosed with autism. He is high functioning, but he's only 8, so we really don't know if he will attend college. Is there a way to transfer these funds to an ABLE account without a tax penalty?
Yeah, so I would have to I don't have the answer off the top of my head. I think there might be ways to do that, but I'd have to look into that because I don't ever like to give advice when I'm not sure because I don't want to lead you astray. So I don't know the exact answer. I would suspect if you talk to the ABLE.
Well, I've done this with both of my autistic kids. I had set up a 529 plans for them before they were diagnosed, and I did withdraw without a penalty because they were disabled. Yeah.
So there you go. I think that's probably the answer. And then
probably yes. Okay.
All right.
Yeah, and you are subject to the $15,000 a year limit though. So if you have more than 15,000, you would have to do it over a couple of years. So they're pretty strict about that limit. But otherwise, yeah, I think thank you, Jill. That's a good answer.
Okay. So here's another question. So if I deposit my assets in my son's special needs trust, are they protected in the event of I get a divorce?
Yes. So money in a special needs trust is no longer yours. So it wouldn't be part of your marital estate. There can be issues if If you're in the middle of a divorce or you're about to get sued or something, and then you put it in a trust, can it be clawed back? I guess possibly. But if you put money into a special needs trust, it's no longer yours. It's only there for the beneficiary. So you can manage it, but you can't use that money to buy yourself a car or to buy yourself housing. So we usually don't recommend that people put much money into a special needs trust until they really have to. Often it's not until mom and dad pass away. And the reason is once it goes into the trust, you can't take it out. But yeah, it's no longer your asset. You've given up control. You've given up ownership. So it would protect it from divorce or law. If you get sued, it would protect it from those lawsuits as long as you put the money in the trust well before you got sued.
Great. Okay, here's an oopsie kind of question. What if we, from lack of knowledge, deposited our child's paychecks, about $480, so not much, into our third-party trust for him?
Mm-hmm. I wouldn't stress. Maybe you take it out. Just make a note of it. There aren't really any police that look at these too closely. If there's small mistakes, I wouldn't stress about it. I would probably take the money back out. Just make a note. Hey, error. We didn't know how these worked, which is totally normal because you're human and you're not an attorney who specializes in this area. So I wouldn't stress about that. If larger amounts, generally try to correct the mistake sooner rather than later, and it generally doesn't cause too many issues.
Okay, this is another question we got a lot of, but one mom is asking, how much approximately would it cost to do a living trust for me and a special needs trust for my 26-year-old? So
yeah, so it obviously varies by law firms. I think so we do it. All I can speak to is the range of fees that we have, and I think we're pretty mainstream. Certainly for the level of expertise we have. From what we've heard from some other firms, I think we're actually on the lower end, but obviously you can always find cheaper if you search hard enough. You don't want to just find the cheapest here though. You want to find the best. When we're doing a living trust for a couple, typically in the $2,300 to $2,900 range, that includes some supporting documents. When we're doing power of attorney documents, which is alongside, that's about $600 per couple. Special needs trust for our firm, $2,900 is a flat fee. We haven't raised that in several years actually. So you have your own living trust, and then you also have a separate special needs trust. So that's kind of the ballpark. There's obviously going to be some additional costs for time to develop the plan and all that, but that's at least the general range that our firm has. And again, you should think about value. Frame this as an investment. If you do it right, it is worth hundreds of thousands of dollars. And again, whoever you work with, you want to feel like you can really communicate with them, that you enjoy talking to them, because you want them to be your planning partner down the road. It's not just creating the special needs trust. It's having them as a thought partner as issues come up, as you coordinate your financial plan and making sure everything comes together, and with your parents' plan and other family members. So you want to think big picture about this, but the fees I just talked about are typically our fees for preparing the documents. But I want you to think about forming a team and having a thought partner who's there for you and your family long into the future.
I'm going to ask this question, even though I'm not sure I fully understand it. If you set up a special needs trust, will income be taxed at trust rate? So
yeah.
if I maintain it when the beneficiary doesn't need it, will the taxation the trust rate despite large distributions to beneficiary? I'm not sure I understand all of that.
Yeah.
Yeah.
Yeah, good question for someone who understands taxes. So special needs trusts are taxpayers. So to the extent that any income that they generate is not distributed to the beneficiary, they do get taxed at trust tax rate. So trusts get taxed at slightly higher, or in some cases, quite a bit higher income tax rates than individuals. And when I say income, that's like if the trust owns a rental property, it'd be rental income after expenses or dividends from stocks. It's not like if you put $1 million in a special needs trust, it's not like that $1 million is all taxed. It's just the income that $1 million produces. So as I gave you an example, $35,000, $40,000 a year in income. Now, if that's paid out for the benefit of the beneficiary, which it often is, the trust issues a K-1, which just means that money's taxed at the beneficiary's tax rate. So it counts as income for him or her. If the trust doesn't distribute that money out, it's taxed at the trust income tax rates, which are a bit higher than those for individuals, but it's usually not that much money. Because again, we're not talking about the principal. We're not talking about all the money in the trust. It's just the income it produces. So it kind of is what it is. There's not really much we can do to change that. And usually not too big an issue, but as long as money's paid out during the year, the income the trust retains and therefore the income the trust has to pay taxes on is usually pretty low.
Okay, this is okay, I'm just going to read this out. Can a special needs trust also lock up your money? And your son or daughter could not really use it, and the trustee ignores basically your kid's needs. So, you know, I guess the key is to getting a good trustee, but I've heard of situations like this, just like you said, you know, the kid wanted to go to Britney Spears and they couldn't go. So Britney Spears is a conservative adult, apparently.
Yeah, she is. Yeah. That's actually an interesting point. That's a very interesting case. But so yeah, there's always that risk that the trustee is the person in charge. You can sometimes create advisory committees, or we can build in other structures of the trust to have other people who oversee the trustee. The problem is that creates weird liability issues, and our firm is big on keeping things as simple as possible. That usually means we don't recommend having multiple layers of review for trust, because we've just seen over time that gets really cumbersome, and you just can't predict what's going to happen 10 or 20 years from now. You kind of have to rely on the fact that trustee is going to be fair. Now, if they aren't, though, there are steps that your child or a representative for your child could take to sue, to say, hey, look, this trustee is not upholding his or her fiduciary duty, that duty to put my child's needs over his or her own. They're not doing it. So there are mechanisms to challenge a trustee. We want to avoid that. And there's no perfect answer here. I wish there was, but there are legal steps that can be taken if a trustee is just not using money. If there's a couple millions in the trust and they just refuse to spend anything for reasonable expenses, yeah, your child or someone representing them can go to court to say, hey, look, we want to replace you, or you got to start spending money.
Okay.
But no perfect solution.
We're going to run through like as fast as we can, but quick question.
Yeah, I have about five more minutes or a little bit more than that. Yeah.
What's the current typical percentage that trustees can take annually?
Yeah, good question. So typically about 1% per year is what we see from professionals. There are some professionals who charge hourly, but you know, when it's there's minimum charges, and so banks or other professionals typically 1%, sometimes a little bit more, because it's like it can be a full-time job to be a trustee. So that's about the range that we've seen. If you have a smaller trust, if you don't think you're gonna have that much in it, well, then it might not be big enough to justify a professional. They might just say, hey, look, I just can't economically make this work. And there are what we call pooled trusts, where there's entities that will manage multiple smaller special needs trusts together. So it's not as much personal attention, but at least they can oversee it and generally manage it in a good way at slightly lower fees, and they can take on smaller trusts. But I would think in your head, 1% is probably the general guidepost that I would use for trustee fees.
Okay, we've had a couple questions about where people can go to buy life insurance.
No, the $1 million one that you have to pay $60 for.
Yeah. Yeah. So we have, you can contact our office. We work with some specialists, some life insurance people who this is like what they do, they focus on. Life insurance experts. I mean, you really want to talk to someone who specializes in life insurance. And these would be, and the example I gave is I don't want you to think that it's easy to get those, but it would be for someone in their 40s, a second to die policy. So the insurance company is like, yeah, it's possible mom or dad could die somewhat young, but it's really unlikely that both of them will die young. That's when the insurance companies lose a lot. But absolutely, we've seen a lot of examples of this, but we have experts with whom we work and who we've worked with for a long time, or you just work with somebody who's a life insurance expert. And these are whole life policies, not term. Term is what you get often through your job. You can find online websites for those. Those are cheap. You can get them for like $30 a month for $1 million in coverage, but those expire. So after 5, 10, 15 years, they're done. So you want a whole life policy that's good as long as you live. And that's where this $50,000 type thing, maybe it's not always $1 million, maybe it's only $500,000. But it can provide extraordinary peace of mind. So you can talk to us, or you can just reach out to a whole life insurance expert.
Okay,
would be someone, and they should know it.
This is the last question. We'll close out with this. What happens to the money in the special needs trust when my child dies?
Great question. So going back to it goes back to the type of trust it is. First party trust, that means that let's say some well-meaning relative left a bunch of money to your child and you didn't realize it until it was too late, and they can't work, or they can't manage it. You can then put the money that your child has into a first party special needs trust. Now, the plan that I'm talking about, that I want everybody who's listening to this call or watching this webinar, I want you guys to create third party trust, where you're leaving money that will never be in your child's name. When you pass away or when you make gifts, it goes to the trust, not to your child. Now, the difference is first party trust. If that money was in your child's name, When they pass away, the state of California gets first dibs. They can say, well, we spent $150,000 on Medi-Cal benefits and SSI benefits. We're going to get paid back before anybody else gets money from that trust when your child passes away. If it's a third-party trust, one that you created, that you left money directly to the trust, never went to your child, the state cannot touch it, and it goes wherever you say it goes. It can go to your other children. If your child, your special needs child, has kids of his or her own, it can go to those kids. It can go to organizations. You know, the Autism Society is a great organization you might put in the plan. Small percentages, by the way, can make a big difference to organizations that serve your child. So we love it when people say even 1% to like the Autism Society. That's great. That can make a huge difference way down the road. But really wherever you want it to go, and you set that up ahead of time.
Okay, Mark, thank you so much for your time and sharing your expertise. Everybody, this was recorded and we will send out a link and it will be posted on our website. So thank you, Mark.
Thanks, guys. Bye,
Thank
everyone.
you, guys. It was so much fun. Take care.